proceed for quality research, then the terms like IPR, patent, trademark, etc. are very much essential. So keeping this view in mind, we have organized this workshop. On the behalf of Research Committee, I extend wholehearted welcome to Dr. N.P. Tendolkar sir, Principal of our college, Dr. Arvind Gulbake sir from National Institute of Pharmaceuticals Education and Research, Guwahati, Assam, Dr. Sardar Patil sir, Vice Principal of our college, all faculty members and students. I welcome all of you. Dr. Gulbake sir will enlighten us about the IPR in detail in his session. Now I request Principal sir for welcome address. Principal sir.
Hello, am I audible?
Sir. Hi, yes.
Yes. Very good morning. In fact, that was on mute. Good morning. At the outset, I congratulate each one of you for your participation in one-day workshop on intellectual property right. I am sure your active participation would greatly contribute to the success of the workshop. Our resource person for the workshop, Dr. Arvind, would definitely explore various aspects of this workshop like patents, copyright, trademarks, and trade secret. It is heartening to witness your enthusiasm and eagerness to learn about the vital topic that play a crucial role in today's innovation-driven world. Your keen interest and thoughtful contribution will definitely enrich your learning experience. In fact, I am very happy to see the number of participants who registered. I could see about 45-50 students they have registered. And that is evident that all have recognized the importance of protecting intellectual property and understanding its implication both for individuals and organizations. Whether you are inventor, entrepreneur, or student, understanding intellectual property rights is essential for fostering innovation, safeguarding creation, and driving economic growth. Once again, I extend my deepest appreciation to each one of you for your participation. This workshop intends to take significant steps towards fostering a culture of innovation and intellectual property awareness within our community. I congratulate all my faculty members, all the members of the research committee, and look forward to our continued collaboration and future endeavors in the realm of intellectual property rights. I wish you very best and thank you once again, Dr. Arvind. Thank you. Madam, over to you.
Thank you, sir. Thank you very much. Now I request Dr. Hemant Savan sir for giving introduction of today's speaker.
Thank you, madam. Am I audible?
Yes, sir.
Yes, you are audible.
Thank you, madam. It's my distinct pleasure to introduce our esteemed resource person for today's workshop, Dr. Arvind Gulbake, sir, Assistant Professor, Department of Pharmaceutics, National Institute of Pharmaceutical Education and Research, Guwahati, Assam. Sir has completed his PhD in Pharmaceutical Sciences, his Masters of Pharmacy and Bachelor of Pharmacy. His entire education he completed from Hari Singh Gaur University, Sagar, MP.
तुमचं रजिस्ट्रेशन करून मी आता लिंक टाकून दिली ज्याला ज्याला लिंक रजिस्ट्रेशन म्हणून नाव लिहायचं.
Yes. हो sir. Sir has industrial experience of 1 year. Later on, he joined the teaching field. Sir has teaching experience of almost 14 years and research experience of almost 13 years. Sir completed 3 major research projects costing around approximately around 70 lakhs. His research area is topical drug delivery, colon-targeted drug delivery, polymeric and lipidic nanoparticles for tumor targeting. Sir has around 46 research papers in well-reputed journals to his credit. Sir also published 1 book and 6 book chapters in various international books. He also has one Indian patent to his credit. Sir also worked as a member of various national or autonomous organizations. Sir also awarded as a Young Scientist Award, Outstanding Oral Presentation Award, as well as Best Poster Presentation Awards, and many more awards in various fields. So it's our privilege, or it is proud for us to have such a eminent personality for the today's workshop. I have no doubt that Dr. Gulbake sir will offer us invaluable insights about the intellectual property rights in the today's session. Thank you, sir.
Thank you, sir. Thank you once again,
Now,
all the committee members, and especially Principal Sir, Dr. Narendra Tendulkar Sir, Vice Principal, Dr. Sardar Patel Sir, Dr. Meera Madam. I met all the members, I think, in 2019. And after that, we are again connecting online. And a special thanks to Dr. Chauhan, Hemant Chauhan Sir, who again connected me with beautiful audience, we can say. And Delhi is a really beautiful place. It is moreover similar to the Guwahati. Like climatic challenges are there. So here also landsliding and those things are there. So we are facing those issues. So let's start, sir. Can we? Can I
yes,
share the
yes,
slides
obviously.
and start? Yes, it's perfectly visible for me.
Yeah, it's visible now.
Yes, it's from your end, sir. Actually, you are sharing. Thank you
Yes,
for
you
sharing
can.
this. Okay, sir. I will tell you whenever the next one is there. I will tell
Yes,
you. So shall we start?
Yeah, yeah.
yes,
Okay. Sorry for the inconvenience, firstly, and good morning to all of you, all the committee member, dignitaries, and dear researchers, can say, and all the faculty members. Very good morning to all of you. So this side, Arvind Gulbake. I'm from IPR Guwahati, as Dr. Hemant already introduced very nicely, and it's an exhaustive one. Okay, so we'll start firstly with the intellectual property right. So can you please go to the next slide, sir, please? So as you aware little bit about this one, that earlier the first news came into the one local newspaper from the Maharashtra itself. There is a lack of patents from the Indian side as compared to the China. We are not comparing the China particularly, but they are doing very well, extraordinary. That's why we are taking it as a reference, and it's our neighbor country also. So as compared to that, earlier it was very less. Still, we are not up to mark, but within last 2 3 years, after 2022 and 23, the growth is quite good. Like whatever in the last 30 year we are not getting, we are publishing almost 50% of the capacity within last 2 years. So from that aspect, you can realize how the government is also recognizing and promoting the patents and the innovations simultaneously with the startups, entrepreneurs that are also based on the patents and innovation. So that's why, in according to this one, we need to somehow protect these our inventions. Otherwise, your invention can be taken up by someone and they can take the benefits by producing your process products and whatever your invention is there. So a special emphasis for the youngsters, even the faculty members, why we need to go for the patent. Okay, so this is government also promoting. Now it is the high time. Earlier, as per the earlier data, the time taking process it was there to publish any patent or to grant any patent in the India, but now it is a very fast track process also, and government is also promoting. That's why you can understand what is the gravity of patent and what is the importance. So can you go to the next, please? Next slide, please. Yes, this one. So previous one plus, sir, previous, yes, creativity. So these all comes under creativity. But what is the difference between the discovery and invention? I think you might be aware about it, but still some confusions in the mind of youngsters that whatever we are discovering that can be patentable. But discoveries, whatever the existing things in the nature, any law or anything, what you discovered first time and showing to the world, it is not patentable. You need to do some process, some product, some outcome like a researcher, then only that things can be patentable. Okay, like one example here, the new species of the animals, new species of kind of already existing things in the world, if it is there, we cannot go for the patent or any kind of claim on that it's your invention. You just discovered it. Okay, that is the already existing thing. So we need to create some invention, then only we can be able to say it is an invention, like the Graham Bell, okay, like Faraday, many scientists, they are doing it. Go to the next one, please. Next slide. So as per the definition provided in the Patent Act, Indian Patent Act also, the invention, it is provided in the section 2 1J. Invention means new process or the new product involving an inventive step, and it is capable for the industry application also. Not only the new product or new process you developed, which is not having any application to the industry, it may not be considered as an invention in terms of the patent particularly. So inventions must be related to the process, means maybe you can develop some new process which can save the time, or which may give you the product which is having little more efficiency, that can be known as the invention, or the product, or the both things, which can be having the enhanced efficacy as compared to the earlier product or the simpler competitive product. So that should have the industrial application also. Okay, it should involve an innovative steps also, some innovative step that can either reduce the time, that can either enhance the efficacy, or that may reduce the toxicity also, in terms of like the green synthesis kind of approaches. So many organic chemicals which are harmful for the nature also, if you are cut short those quantities of the organic solvents, green synthesis process kind of example, then maybe it is known as the innovative steps or the process, so that you can go for the invention. Okay, it should have again the industrial application part, and it should not fall under the section that is very important, section 3 and 4, which are non patentable. We will see this part in our next slides, but these are the important section 3 and 4, what we cannot consider as an invention. It may be an invention, but we cannot consider for the patent because it may be harmful for the society, or it may be more useful for the generalized society, like the medical equipment or the medical processes. So government stopped that kind of things to go for the patent. Next one, please. Next slide, please, sir. Yes. That is very interesting one. Why the patent or IPR, intellectual property right, the full form of IPR, intellectual property right. What is the importance of this? So for the different person, uh, depending on their experience, expertise, they are having different reasons to get the IPR. Like for me, it's for reward of the original effort. Whatever originally I have done the efforts on to develop some process or product, for that I want a kind of reward. And for student also, they are also develop such kind of invention for the reward that can give some good business ideas, or they can promote their business, or they can do some good research in that one. Some, it stimulate the innovation and creativity of the ecosystem of the research. It also prevents simultaneously the duplication of the work. Maybe we can search firstly if some idea comes in our mind. Is it a novel idea, or is it already existing? So for that we need to go for the literature review, go for the internet, Science Direct, PubMed, different sites are there. We can see the publications are available related to that one or not. Similarly, we need to search on the Indian patent side or US patent side to see whether it is already existing or it is a new one. So that can prevent the duplication of the work also simultaneously. So we should avoid the duplication, and before starting to for the research, we should focus and see a literature review properly through the patent site also and through the literature sites also. It should obviously, if there is some invention, new process, or the new product, it should have the commercial value in the research. So we can get some good means remuneration for that one, good funds for that one. And it also prevents the exploitation of the workers or the researchers. So anybody cannot take up your work as such if you are protecting your invention through the IPR. Okay. So technical information for the research and to prevent any kind of litigation, that can also the IPR, we can take the advantage. Next one, please. So now coming to again the basic definition, intellectual property. It is the property that has been created by the exercise of intellectual faculty, or we can say any person of the intellectual thing. If he developed any property, means invention, that is his property. So like same kind of property, land or any mm, home, we should register it at the local office also. Similarly, this kind of intellectual property, where to register? We need to register it in a patent office. So intellectual property right are the right that is given by the government. For Indian patent, we can consider it as a Indian government. For the international patent, we can consider it as world. Okay. So government giving the right to the inventor to protect their invention from the others, so that you can only use it. And if somebody is using your invention for their benefits or reproducing the product, then you can claim it and you can take the you can stop them, or you can take the whatever the remunerations are there, you can take that one also. Okay. So generally the intellectual property rights under this patent is the important one, but it is not only the thing. There are other things are also there: copyright, industrial design, layout design, trade secret, trademarks, GI, geographical indication. So those are the different parts. We will go by one in the detail. Next one, please. So types of IPR that we already covered. Next one, please. So these are some important laws in India which are related to the IPR. So firstly, we can start with the Trademark Act, which was under the Act of 1999. Copyright, which is under the Copyright Act 1957. Designs, like the any kind of new design of any apparatus, any car, any mobile, anything, any kind of product, if it is having the new design, you can get the patent on that one, design patent. So that Design Act comes in 2008. That invention, like the product and process, that patent comes under the Patent Act 1970. Plant varieties, earlier it was not considered in the Indian patent one, but after 2001, that plant variety and farmer Protection Right or Farmers Right Act that was introduced in 2001. Integrated circuit, that was also not in the Indian patent earlier, uh, but in 2000, this act, semiconductor integrated circuit layout design, that introduced into the 2000 act. And then GI, geographical indication, that act comes in 1999, and that comes into the force by 2003 onward. Next one, please. So, if you see about the patent, it is a set of exclusive right which is granted by the government to the inventor to protect his or her work from the others. Okay. Can I take just 1 minute break? Just okay. I will come.
Yes.
Yes. Sorry for the inconvenience. Okay. So patent we already discussed, but what are the different parts or types of the patent? So biological patent, business method patent, chemical patent, design patent, ordinary patent application, and application for patent of addition. We can do the additional things also in the same patent again. Uh, Mainly, I can tell you the business method patent is not available in India, and biological patents are also in a very limited one. Okay, next one, please. Uh, yes, these are the important sections where what are the things which cannot be patentable. Okay, so inventions falling within the section 21 of the Atomic Energy Act 1962 that are not patentable, like inventions relating to the compound of uranium, beryllium, thorium, those whatever and more, whatever notified in the central government by that government agency, that we cannot go into research with those things, and those are not patentable at all. New use of the existing product, for example, any drug or anything which is well known and well existing for one purpose, and if you are saying it is now we are want to patent for the different application of the same product, that is also not possible. Cause harm to the human or environment, anything which may be harmful for the human being or the environment, it cannot be patentable. Like if you want to make the machine which can break the home houses or the different places, that cannot comes under the patent one. Okay, that's invention is not patentable. The process for diagnosis and the treatment in the medical conditions, those are also not patentable. It is mainly due to the benefit of the society. So whatever the general method of treatment, diagnostic things, that uh, are not patentable. Otherwise, those charges would be high, and it is moreover the societal benefit. So government excluded that one from the patent. Scientific principle, abstract or theory, that are also non-patentable. Any mathematical model, computer method, or software or horticulture, those are also not patentable. Okay, next one, please. So this is a kind of organizational chart where these different offices are in the India. So we can say patent office, mainly covering the Patent Act 1970. If you want to go for that one, or Design Act also 2000, that are mainly focused in Kolkata, New Delhi, Chennai, and Mumbai. Okay, I will tell you where your territory comes under which one zone. That next slide I will tell you. Patent Information System, that is the single office in India, which is located in the Nagpur. Copyright Act, similarly, it is the single office we need to apply at the New Delhi office. Trademark Registry, that is again available in the New Delhi, Kolkata, Mumbai, and Ahmedabad. So these are the places where the offices are available. Next one, please. So regional patent office with the particular jurisdiction. So you can see where your state comes the patent office nearby. Obviously, you are in the Maharashtra, and Mumbai would be the better option. Okay. Similarly, with the rest of India, Kolkata and different parts, they are divided in a four zone, and these are the specific thing. But more important for all the people from the Maharashtra, that comes under the Mumbai one. Okay. Next one, please. So patent protection in India, different milestones are there, which are more important to just see. Okay, 1856 protection from the invention or any invention formally started in India based on the British patent law of 1852, because that time Britishers were there. So maybe that followed the same things. In 1911, the Indian Patent and Design Act comes. Product patent and composition of matter patents, that are all comes under 1970 Patent Act, Act 39 of 1970, which came into force from 1972 onward. Only process patent in pharmaceutical, agrochemical, and food, that were there under the section 1970 up to 2000. And after, if you see the last amendments, 1999, 2002, 2005, in that amendment, the product patent for the food and agrochemicals and chemicals and drug even, that all comes under the different amendments. Okay. Important thing, WIPO, World Intellectual Property Organization, India joined that one in 1975. In 1994, India joined this General Agreement for Tariff and Trade Agreement, that also signed by the India in 1994. In 1997, India became the member of PCT, that is the patent contained territory, and then you can file the international patent also. So this one 1997, this is the good step, so we can directly file the international patent also, that is called the PCT. Next one. A little information about the WIPO. It is one of the 15 specialized agencies in the UN, and it was created in 1967 to encourage mainly the creative activity and to promote the protection of intellectual property throughout the world. WIPO currently has 191 members states and administers 26 international territories also. Its headquarter is in the Switzerland, Geneva, and currently the Director General of WIPO is Professor Darren Tang, and it mainly promotes the protection of the intellectual property throughout the world. And from that report, WIPO gives the report in 2023, very recent one, and it is also saying the same thing. India is growth is the highest. Means last 2020 it was around 25% growth, and in 2023 it was more than 30% growth in the patent specifically from the India. Okay. Next one, please. A new bill passed by the parliament in May 2002, and some silent features are there. In that one, they increased the term of the patent. Earlier it was the 14 year, and now it is the up to the 20-year. You can get the privilege of your invention. A group of inventions linked to a single invention, innovative concept that can be covered in the single application. Like if in between you want to incorporate something in the same patent, that feasibility is there after 2002. The concept of inventive step has been defined for the first time, and definition of the food is restricted to the food for human consumption only, not to the other one. Okay, next one please. So this is the important thing. What is the major differences between the Indian patent and the US patent? In the US, it is the concept of first to invent system. That means whoever first invented the thing is known as the inventor, and he is having the right on that to patent, to file the patent, that kind of. But in India and Europe simultaneously, there are different culture. It is first to file system. It means it is not a matter who invented, it is the matter who filed the patent firstly. So simultaneously, that should be remember in Indian system, we need to file the patent. If you are having some concept and you are sure about it little bit, so you can go for the preliminary patent and you can file it, and you are having 1 year time to complete it. The complete specification you can submit later on, but pre-patent application can also be filed in the India. So first file system is there. So better to go firstly to the patent office. Okay, in Indian system. US patent law only applicable for the post grant apposition. If any in the public domain, because the patent is published in the public domain after your application, and before granting it is a process of 2 3 year minimum. So anybody, if they want to take any objection that it is already existing invention or kind of thing, or it is similar to that one, so they can take the opposition. But in US, opposition only you can take after granting the patent. But in Indian system, if it is in a published form, not granted one, you can appeal for the opposition of that patent, pre-grant as well as post-grant. So you can appeal it at both the time point. Plants are patentable in US, but plants are not patentable in India. But after 2005 onward, some specific genetically modified plants variety and Protection Act comes under 2001. So after that, that can be with limited things that can be patented. Business methods are not patentable in India, but in US you can go for the business method, like the online business method or any other kind of platform if you are going to develop for the new business ideas. So that can be patentable in US, but not in India. Similarly, softwares are not patentable in India, but in US it can be patentable. Okay, software, there is a one logic people are saying for that one. If you want to go for the patent for the software, you can go in India. There is a provision you can go for the copyright, not for the patent for the software. Next one please. Now little bit briefing about what are the important things and how we can go for the Indian patent filing. So basically, what are the documents required to file the patent? The all documents should be in the A4 size paper. Okay, that is the most important thing we should be always keep in mind. A covering letter, similarly with any kind of submission projects or patent, we should make the covering letter uh, detailing about the title of the invention. It may be the process or the product patent, so detailed about that one. and addressing to the controller general of the patent, and a rightly filled application form 1 in a duplicate form number 1. Information regarding the foreign filing, if you are simultaneously applying in a foreign country, then you should file the form 3 also. Proof of right apply, that also you need to publish. Prescribe fee, and in terms of cash, check or DD, whatever, that should be also mentioned in and simultaneously attach the DD if it is there in the name of controller of patent. Patent specification form number 2 is there, and that you need to fill all the details like patent search also, or similar kind of any invention is there. Those things are also we need to provide, and what is the difference, what are the claims in the patent, that also we need to give in the form number 2. Abstract, similar to any article, the research article, we need to make the abstract in a 150 words telling about your invention, what is it, mainly the background little bit, and a specific claim related to that one. Drawing if required, any kind of graph, sketch, that things are there which can explain your product quality or superiority, that can also be inbuilt. Power of authority, if applicable, that single copy also need to be submit. Request for examination, that is again you can go for form number 18 in the next one. Go to next one, please. Precautions, what kind of precautions to be taken by the applicants? These are very important. Reply to first or subsequent examination report very promptly. There's 1 year duration for the uh, FER, whatever the examination reports come from the patent office, we need to respond it within 1 year. Pursue the case personally if the last date is very near. So don't communicate through the letter or anything. Personally, you can approach. Don't forget to take the hearing under section 14 if you are aggrieved. Herein under section 14, applicant not satisfied with the objection. If anybody taken the objection, if you are not satisfied, you can again raise the issue and put your issue in front of the patent office. Ask for hearing from the controller at least 10 days prior to last date of the grant of application. Controller issues the decision on your hearing. After compliance of all objections and decision in favor of you, that applicant, you can grant the patent. Next one, please. This is a form 1 which need to fill up very basic detail about the inventor. Next one, please. Coming to little process about Indian patent filing. So just a brief idea, not in detail, I am going to give you. So a start point, either we can go for the provisional patent or the full patent. If you are going for the provisional patent, you need to fill the complete specification within 12 months. 1 year time duration with you. If you think your idea is new and any other persons can patent it, so you can file a provisional patent, and then and they will go for the examination, and that report come to you, first investigation report. Now you need to submit the reply within a year time. Okay, then if it is accepted, then you grant the patent. If it is rejected, then the patent is denied. In that time you can appeal again if there is anything. If your appeal is accepted, then patent is granted, otherwise it is rejected. So this is the simple process, which is if you speed up all the 2 3 processes, you can get the patent grant within a 2 to 3 years. This is also the process in different timelines. So you can see this PPT again to see the details. It's again the repetition kind. Next one, please. So now coming to little bit introduction about the copyright. Okay. uh, these things mainly we can say more interested for the peoples who are in the literature work, music, art, those. uh, but scientific one also we can, like a lab manual, your brochures from the college itself, your one SOP, that also you can go for the copyright, or any kind of book also you can go for the copyright. Okay. So main objective to ensure the protection from the unlawful exploitation of the work of the owner of that work or the author. Copyright Act provides exclusive right to the authors and other owners of the original work. That exclusive right, what you remember, I think I can tell you some incidents that are not very recent, but 2 3 year back. Whatever musics they are producing, that are original one, and they are also took the copyright on that one. So that Bollywood music, especially I'm saying Bollywood music serials, they are using the clipping for 2 3 minutes in their regular serials or any other things. So that kind of case goes to the again court, and court give them the privilege and strictly warning to this serial directors and other members that you cannot use this clipping more than 30 seconds. Now they can use this song or the music for 30 seconds, not more than that. Otherwise they are freely using it or not paying anything to the original author. So for the protection of that, court gives that order, you can use it, but up to 30 seconds, not more than that. Exclusive privilege to the author to reproduce, distribute, perform, display their creativity. That exclusivity, that can be with the copyright author or the inventor, here we can say creative work. Next one please. So this all comes under the copyright. Literature or literary work, dramatics, drama, any kind of script, musical instruments, music, those any kind of music is also there. Artistic pictures, that also comes under the copyright. Sound recording, music recording, films, that all comes under the Copyright Act. Next one please. Next one please. Next, I think one more is, so what cannot be registered as a copyright? If design published in India before the date of registration, if it is already there, it cannot get the copyrighted, and you cannot register it. If design is registered in India previously, then also you cannot go. If it is not new, not a original one, then it is not registered as a patent one, copyright. What are the ideal characteristics for the copyright? The design should be new or original one. It should not be published in India at the application date of registration. Design can be related to two features like shape configuration and the pattern. Then only it can go for the design. Design should be applied to any article by the industrial process. That is the ideal one for the copyright. The features of design in the finished articles are to be judged by the eyes. It should not be the microscopic design. Okay, so it should be judged by the eyes easily. That can be registered as a copyright. In design, it should be not include any stamp, any label or card in any design. Next one, please. Trademark. That is very interesting, especially for the businesses, or exclusive for the brand building. Okay, so word or a symbol used by the manufacturer to identify their goods, they are using this kind of trademark. And that is very important to build up any kind of brand. Your college is also having one logo that may be registered as a trademark. It is often a brand name, but it can be any sign which capable of being represented graphically, including a picture, signature, any color, any numeral, or any kind of shape, configuration, pattern, or a container of the good that can be registered as a trademark. Customer can easily distinguish the product of one manufacturer from that of the another. Like detergents are having different varieties, cold drinks are having different varieties, different brands in the market. How you can recognize easily that you want a Coca-Cola, you want Pepsi. So that cap, that bottling, those things, their pictures, their colors, those are protected through the trademark. So similar kind of things cannot be duplicated into the market. Initial registration, we can go for the 10 years, and further it may be renewed uh, by the payment for the unlimited period of time. Next one, please. So this is a beautiful example. We can see trademark, the name like mentioned in the Coca-Cola. Okay, logo type Nike. You all remember this one. The right sign only. It's not a new one, but differently. So they registered it. Symbol of McDonald, that M, they differently write and registered it as a trademark. Slogan below that McDonald M, I am loving it. That slogan may not be new, but they write it with this combination, and that's why they registered it as a trademark. So both the things are registered. Color, that orange, that is also, they mention the same word, same color, but in a particular combination and dimension. So that reflects the, they can register it as a trademark, and that is already registered one. Next one, please. Again, this Pepsi, Coca-Cola, different symbolic trademarks are there. So benefit is there. We can means your customer can easily recognize the product and its services through this brand building trademarks. It increases the degree of satisfaction in the customers that that brand is specifically pure and with some trademark, that symbol. We are looking for that symbols usually, like the Apple iPhone, we can say. Android phones are also working fine, but people are more crazy about that half cut apple of the Apple iPhone, we can say. Increase the market value, that how the Apple iPhones, they are increasing their market value of the product. That's why that symbol and trademark is very important. Have the significant commercial value, and it protect from the local market also. Okay, anybody cannot duplicate it because your this one is already registered. Your logo, your trademark is already registered, so nobody can copy it. So that protection we should get it. So forms of the trademark that we already covered, it is the color combination, 3D design, audio, sound, music notes, some, or it is up to approved up to 7 years, and registration fees for the trademark is 2,500 only. What cannot be registered as a trademark? That is also important one. A mark does not confirm with the definition of trademark cannot be registered. A mark which is not capable of distinguish of the product or services, that you cannot go for the registration. Any mark which is similar to the other trademark which is already registered, you cannot register it. Any mark which is related to the particular religion, it is identified with combination with religion, that cannot be registered. A mark where the application for the registration is in the bed faith, the flag of the republic, those kind of slogans or things cannot be registered. Any words or symbol which causes confusion cannot be registered. Any word or symbol which is unlawful, that can also not be registered as a trademark. Next one, please. Symbols. So, who can use the symbol R registered in India? Only the proprietor of a trademark whose trademark has been registered in India can use the symbol R in circle in India. Using a symbol R, unless your mark has been registered in India, is unlawful. You cannot use the R mark with your symbol. Okay, take the new symbol, but you cannot write it as a R in that one. Okay, when can the symbol TM be used in India? Using this symbol with your trademark simply implies that you claim to be the proprietor of the trademark, and there is no prohibition on the use of the symbol TM in India. If you are the proprietor of that trademark, you can use it easily in the India. Next one, please. GI. That is very interesting one. And nowadays, almost all states in India, they are registering their special things with this tag, geographical indication. So indication which identifies such goods like the agriculture goods, natural goods, or the manufactured goods which are locally manufacturing there. So these are the symbolic things of the local geography as originating or manufactured or processed in the territory of the country or locally of the territory. The quality and the reputation of such goods are attributable to geographical origin particularly. Like for example, Kolhapuri chappal is available throughout the India, even in outside India also, and people are selling in the name of Kolhapuri chappal. But after getting the GI for the Kolhapuri chappal, that is well recognized because other peoples are copying that one, the Kolhapuri chappal, but the strength, the leather originality, that things are not there, and even more specificity are there in the Kolhapuri chappal. Giving them some example from the local. Next one, please. More examples are there. So you can easily see from the Indian map. That is old one. I can show you the new one also. Jaipuri, Rajasthani. That some designs that are getting the GI from the Rajasthan. Chanderi fabric from the Madhya Pradesh. Kutch embroidery from the Gujarat. Solapur chadar from the Maharashtra, Solapur area. Mysore silk from the Karnataka. Many examples are there. You can see from the Kani shawl in that Jammu and Kashmir, Kuttu shawl from the Himachal Pradesh. So many are there. Okay, that Badni printing from the Bihar itself. Next one, please. This is more interesting one. Kolhapuri chappal, Puneri pagdi. Okay, I think you all are well familiar with these things. Lonavala chikki, Assam tea from the Guwahati or Assam side, northeast side. You might be not familiar. Haldiram Bhujia, that is the product from the Nagpur itself. Some other liquors are also registered as a GI. Next one, please. This one again, oranges from the Nagpur. Kangra painting, Tirupati Laddu. They are also Balaji temple, that Laddu Tirupati. That is also registered as a GI. Tulapanji rice from the West Bengal. Andhra's mango, Kashmiri Pashmina from the Jammu and Kashmir. Next one, please. These are the new one. You can see later on. These are all details with the different parts. So what the other GI from the different part of the India, they are getting the patent. Especially the Jalgaon banana. Recently, they got the GI from Maharashtra. Okay. Next one. design design patent. That is also interesting for the student. If you see, if you are working with some instrument in the lab and you are thinking this some modification in the instrument design can make more easy for the experiment, or maybe some modification in the design can give more strength, some novelty in that design. If you are able to recognize it, you can get the design patent also. Okay, simply design patent. If you remember, some 4 5 year back, one good case was in the news. Apple iPhone versus Samsung some smartphone. The design are almost same, so that's why Apple imposed some case, and he won the case, and Samsung pull back his all the product of that design from the market itself. Okay, so those kind of things are there, and penalty was also imposed on the Samsung. So these things are there. Design patent, that's why is very important. If you design something, you created a new car design also, you should go for the design patent. Otherwise, a similar design can be opted from any other company, and they can also make the same models kind of. So mainly design, it includes the shape, configuration, composition of the colors, lines. So these are called as a design. Main criteria for the design patent: novelty and originality. It should be novel design and original one. It should be not the copied from the already existing one. So registration of the design can be done currently under the government by the Design Act 2001, and you can get the timeline up to 15 years total time, and initial right is granted for the 10 year, and then it can be extended for further for the 5 year by making the application along with the necessary fees also. Next one please. So these are some examples for the design patent, like the shape of the pen drive, design of the car, even for the cup. Okay, that is also coffee mug, Starbucks. That is also patent as a design one. Any medal, mobile phones, shoes, any kind of product. If you are having different design, you can go for the design patent also. Next one, please. Plant variety. Singapore coconut, legal protection granted by the government for the protection of plant variety and the right of the farmer and plant breeder particularly. So that provided by the Protection of Plant Variety and Farmer Act 2001. Next one please. Integrated circuit. These common circuits may not be registered in India as a patent one, but the super capacitor related that integrated circuit can easily be registered as a integrated circuit patent in India itself. Okay. Next one, please. Approaches to the protection of the IPR. So that is the question for the audience. If somebody can reply this question, suppose you invent a laptop or some laboratory equipment or apparatus with some new features. How you are going for the designing or registration of this? It is the patent for the technology, design for the appearance, trademark for its brand, copyright for the accompanying literature. How you are proceeding? So this is the kind of question for your homework. You think about it. Okay. Next one, please. So this is a. I'm giving the glimpses of the beautiful campus from the Naipur Guwahati. It is the Center of Excellence Institute, and Institute of National Importance also. So National Institute of Pharmaceutical Education and Research, Upper Guwahati. Next one more picture, which is the close-up. You can see. Yes, this is the front building. It is the very small institute, you can say, only having 400 students, PG and PhD only. No graduations students, graduate students are with us. Only post-graduation programs in different 8 disciplines and PhD program. So thank you all of you for listening me very patiently, and sorry for the interruption. That's it, sir.
Thank you very much, sir, for
Thank you.
detailed session. I want to extend my deepest gratitude for your invaluable contribution to our workshop, particularly on IPR. During your lecture, you have focused from basics of IPR to how to register for the patent. Also, you have focused on laws, acts, and detailed information related to patent, trademark, GI, and copyright, etc. Really, sir, your expertise will definitely empowering participants to grasp the significance of IPR in today's innovation-driven era. Thank you very much, sir. Sir, I have done my PhD under the able guidance of Dr. C.D. Lokhande, sir, and
I remember them.
still we met during the academic programs like conferences and workshops.
Yes,
And when in 2019, when I requested Lokhande sir for workshop, he suggested that plan one session for Gulbake sir. So I
yes,
remember your visit and your exhaustive session related to IPR in our college in March 2019 also.
yes.
Thank you once again for very much informative and insightful lecture. Thank you, sir. Now, I would like to request Dr. Sardar Patil, sir, Vice Principal of our college, for concluding remarks.